Morning, everyone.
Morning.
You brought the sunshine with you today, which is good. So we've got a nice sized group here today. So I'm going to run through some slides on international recruitment and what we've done. And if you've got any questions, then feel free to sort of ask or raise your hand or put it in the chat box. I'm sure Megan will sort of stop me in flow because I can't always see the questions and things.
Yep, absolutely, will do.
So I can try and deal with queries as we go along. So that'd be great. And it's going to be an interactive session. I don't know how much any of you already know, or whether you've embarked on the process or anything like that. But we can try and sort of deal with any queries that you've got as we go along. I'm not sure what you can see on your screen because I'm seeing the first slide and then all the slides along the bottom. Is that right, Megan? Or
well, we can just see the first slide. So if you click along to the second.
Right. Okay. I wasn't quite sure.
That's all right.
So I'll move on. Right. So basically, just to run through it, there are a number of tiers that the UKBA sort of operates in terms of allowing migrants into the United Kingdom to work. The primary one that concerns sponsors and providers like ourselves is the Tier 2 category. And those are the ones that allow you to bring in sort of senior carers and carers from overseas. So just to give you a little bit of background, prior to Brexit, we had basically an EU-wide labour market. That's obviously been taken away from us, but what they've done is replace that with a sponsorship system that allows you to bring in recruits from anywhere around the world, but you have to sponsor them and it's controlled. So in my opinion, probably a better system than what was there before. I guess the key benefits that we've seen is that when you sponsor a migrant worker, you sponsor them for a period of up to 3 to 5 years. So effectively, you know that you've got that person with you, providing you look after them, they're with you for 3 to 5 years. And that's something that you can't really say, couldn't say before they introduced this system, because people had come, they'd be with you for a month, they'd move on, different jobs, different providers, different locations. Here you've actually got people, you've got a labour market that actually wants to come and work for you. So Tier 2 is the main category. The other tiers don't really apply to us at the moment. However, Tier 5 may be an option, but that includes youth workers and people sort of almost like travelling holidays, for instance, and they might come and work for 6 months and work for you or with you. But really, the Tier 2 sponsorship route is probably the best route for sponsors. So just to go into what Tier 2 sponsorship is, it is basically the most frequently used route for skilled workers to come from overseas into the United Kingdom. And again, like I said, following Brexit, we now have to use this method of sponsorship to recruit for anybody from outside the UK, or anybody that doesn't have the right to work in the UK. So they may already be here as a student and want to stay on, or they may be a nurse from the Philippines, or a skilled worker that you want to bring in. So in order to actually be able to sponsor people for a Tier 2 visa, you have to, the worker has to demonstrate that they have a job offer from a licensed sponsor holder in the United Kingdom. So for those of you that don't have a sponsorship license, that is really the first step. You have to be an approved license holder with the UKBA in order to sponsor people from outside the UK. That license then is granted to you for anywhere up to sort of 5 years, and that allows you to basically recruit from overseas. So it's effectively a permission, if you like, that allows you to do that. So becoming a sponsored organisation basically gives you the right to issue what is called a certificate of sponsorship. A certificate of sponsorship, quite often known as a COS, it's a document that you produce, and it's done virtually, and you enter in the candidate's details, and from that it will produce a reference number or a virtual document, I guess as we call it, and that then has to be provided to the candidate that you've employed, and that has to form then part of their visa application process. Some common mistakes that are made is that people think providers have fallen into a trap where they've actually issued a certificate of sponsorship and think immediately that they can employ that person. That's not correct. That it is only one document that they need. So the rules are changing pretty much all the time, unfortunately. So that candidate then effectively, if they're in the UK, has to have a right to work, and if they're outside the UK, they need a visa to come to the UK, and this document will form part of their documentation that they need to apply for that visa, and I'll go into that in a second. Okay, so the new system that was introduced after Brexit was basically a points-based system, and the candidate needs effectively 70 points to enter the United Kingdom. So if you look at the list that I've given, I've highlighted the points that are applicable to providers like ourselves. So to make up that 70 points, they first have to have a job offer letter, a secure job offer letter, and that basically means that with that job offer letter they have to have that certificate of sponsorship, and that gives them their first 20 points. The job also has to be at an appropriate skill level. So for instance, you can't engage for instance a domestic member of staff. They have to have a certain skill, which it's called a RFQ qualification, and it's the level has actually been lowered in the last year. But anybody that's got any sort of skill or qualification in care or nursing will automatically qualify for that. And that will give...
Raj, oh sorry, just to say, we've had a comment in the chat. Michelle said, we've just been advised our application for sponsorship has been granted. However, it says 4 years, not 5.
Right, so it varies depending on the time of year that you apply. Their years run up to April. So if you apply, I think on the 2nd of April, you then get that extra period. Otherwise, it's 4 years. Yeah, I mean, it can be anything. It depends on what they grant. So it can be anything between 3 and 5 years, really. If you extend it, it could be 5 years. It just depends on the rules at the time, and they do change them quite regularly. So 4 years is long enough. And after that, you just basically reapply. You don't make another application, you just apply to extend your license. So yeah, the second 20 points is for the skill level, and the next lot of points that's highlighted is the English language skills. So they have to have passed an IELTS exam, or they have to have done a degree that is taught in the English language in a recognised university or country, and that will give them a further 10 points. So now you're up to 50, and the remaining 20 points is now made up by the fact that carers and senior carers are on the shortage occupation list, and that gives another 20 points. So effectively, with those 4 items, they now have the 70 points that they need to make their visa application. Of course, that as it says there are other things that will give them additional points, but they're not really applicable to care staff or senior carers unless you're employing somebody with a PhD or a doctor to actually sort of run a facility or something like that. And you can see the other way to get additional points is by paying them a higher salary. But we all know what the carer sort of rates are and the senior carer rates are. So these are the best ways for you to make up those 70 points. So, going forward, the person that just commented saying that they've got their sponsor license. Now, this is another slight sort of pitfall in the system, and it's not very clear. There are actually 2 types of COSs. So when you get your license, you'll be allocated you'll get a license summary basically on the front page, and what they do is they give you a number of what we call undefined COSs, but they don't actually show that on they don't show the distinction between defined and undefined COSs. So I'm just going to go through very quickly what the difference is and how you can sort of deal with that. So a defined COS is for employing somebody that is not currently in the UK. So if they were in India, Philippines, wherever out, they could be in France, Germany, they could be anywhere. And there you need to issue what is called a defined COS. So when you've applied for your license, you won't get an allocation of defined COSs because it's hidden in the sponsor management system. What you'll find is that they'll give you a small allocation of what we call undefined COSs, and those are for people, the migrant workers that are effectively already in the UK. So that could be a student that's finished a degree, or that could be a student that wants to transfer from being a student to an employee, basically. So they have to switch categories. Now, it is quite common for migrants to come into the UK with, as a student and almost immediately look for employment and then want to switch from being a student to an employee. So they'll want to switch. And for some reason, the government allows that, allows migrants to do that. So those are the COSs that you will be issued on your license summary. If you want to employ somebody from outside the UK, as I said, you need defined COSs, and those you have to make a separate application for. And again, I'm not going to go into details of how the system works today, but if you've got any queries on that or need some help or whatever, I'm sure Megan will share contact details, and you can sort of ask that afterwards if you like. Okay, so salary requirements. So one of the criteria is for jobs on the shortage occupation list. Effectively, it works out that you have to pay all your migrant workers £10.10p per hour. Now, again, in the government's wisdom, they've set the same rate for carers as well as senior carers. That is the minimum rate that you have to pay. And that was obviously before, that was last year. So now with the national minimum wage rising in April, that might be more in line with what you can and do pay or will pay after April. So that might fit in better. However, from experience, if you're going to pay a carer £10.10p an hour and you can pay a senior carer £10.10p an hour, why wouldn't you have somebody that's more qualified and able to be a senior rather than just a carer? It makes sense to have a better qualified person than a lesser qualified person. So the way the rate is calculated, I've sort of put down, your salary offer needs to be a minimum of £20,480. So you can't employ somebody part-time, and that has to be for 39 hours a week. And if you divide that up, you can see basically it's 20,483 at £10.10p an hour, and that's the minimum that you have to pay. Not quite sure how that fits in with everybody's pay rates. Is that in line? I mean, what we did last year is that we increased our pay rates to match. And I think one of the arguments that some sponsors had was that, yeah, we can't embark on this scheme because we can't afford those sort of pay rates. So obviously one of the things that I know that we've put this to Norfolk County Council in terms of looking at their funding, and I think they are sort of raising rates or expectation of pay rates in the coming year when the new fees are sort of announced, which then does allow you to pay that rate if you don't already pay it. Okay, so there's also quite large cost implications as well for providers. It's not a welcome cost, but what we've found is that actually it's probably well worth the investment for two reasons. One, you can mitigate your use on agency staff, and the additional cost of having agency staff, as we know, can be quite horrific. You know, if people don't turn up, or employing extra people at sort of 20 or even £30 an hour just to cover your shifts can be quite expensive. So you've basically, I've listed some of the costs there. You effectively got you've got your application fee for becoming a sponsor license. For every certificate you issue, and I'll go through the detailed costs in the following slides. You have to pay a fee for every certificate that you issue, and I guess for us, one of the biggest costs was the immigration skills surcharge. So every person you employ, you have to pay. It's almost like a tax, if you like, which is what they call an immigration skills surcharge, and that's calculated per annum on obviously the number of years that you sponsor that person for, and those costs have to be borne by the employer, unfortunately. So the employee then also has to pay their costs as well. So for healthcare, we're actually exempt from the health surcharge. So that's good for the employee. Previously, I think they had to pay like £700 odd just for the health surcharge, which they don't have to pay now. They also have to pay their costs relating to their visa application and any costs relating to processing that visa if they hire a solicitor to do it, which I would recommend because it's not the easiest thing to do. And they also have to show that they can maintain themselves for the first month as well. Now, there's a way around that, because obviously if you're getting somebody from, say, India, for instance, and they have to show that they've got £1,500 in their account, and it has to be for a period of over 28 days, that's quite a large sum of money from the country that they come from. There is a way around that, and what we've done and what we do with our migrant staff is that when you issue the certificate of sponsorship, there is an option that the provider can effectively guarantee that, and if you tick that, then the employee doesn't have to show that amount of money in their account, so it makes it a lot easier. Okay, so just, I guess, running into the costs and things. Let me just get this whole slide up because it seems to come up backwards. Here we go. So when you're applying for a license, the license fee itself, for most small providers like ourselves, it'll be £536. and that's payable when you actually apply for your license for sponsorship to the UKBI. Larger sponsors or medium-sized sponsors, which effectively is larger companies that employ more than I think it's over 100 people, have assets worth more than £5 million and a turnover more than £10 million. It's a combination. If you do two of those three things, you then fall into the larger category and pay the higher fees. But I think most providers will fall under the small sponsor category, and your application fee is £536. And as I said, once you've got your license and you issue each certificate that you issue, you have to pay £199, but that is when you actually sponsor the person, not prior to actually making the application for the number of certificates. Also, when you issue the certificates, apart from the £199 that you pay, as I mentioned, you have to pay the immigration skills surcharge. Now, that's calculated on a per annum, I think it's per annum basis, and then you can break it down into 6-month periods. Now, what we've done, we've sponsored people from outside the UK for a period of 3 years. So we pay the whole lot. It's all payable in one lump sum right at the beginning. So it's a little bit unfortunate, but so if you employ somebody for 3 years or you sponsor them for 3 years, it's 3 lots of £364. But if you do it for, say, 18 months, for instance, then it's 364 plus 182. But what you've got to remember is that after 18 months, you then have to go through the same process again and issue another certificate of sponsorship if you want to keep them, and then pay the surcharge for the remaining period that you sponsor them for. So it's probably better to sponsor them for that 3-year period. If they leave beforehand, then you can claim some of that back. So it's not lost money, but it's what you call I guess, an investment up front. And again, that fee changes. If you're a larger employer, then you pay £1,000 for the first 12 months and £500 for every 6 months after that. But I think most providers would fall under the smaller category, and it's basically just under £1,300 to sponsor somebody for 3 years. So the sponsorship, the certificate fee and the skills immigration surcharge, I think is just under £1,300. So you've got to bear that in mind. But if you compare that to the cost of using an agency, it sort of does pale into insignificance, really. But if you're employing sort of 5 or 6 people, then suddenly you find that you're going to be spending sort of £6,000–7,000. Okay, so being a sponsor, it's no easy task. The UKVI is very, very strict on issuing the licenses and also maintaining those licenses, and literally passes on responsibility for immigration under this category to the provider. You have to basically maintain what is called a sponsor management system, known as the SMS. As a sponsor, you really have to understand what your responsibilities are. It's a legal requirement of having that license to hand. And there's so many things that you have to report on there, and they do have the guidance on there, but it runs into sort of hundreds and hundreds of pages. So things like any organisational changes, for instance. So if your structure changes, you have to report it to the UKVI. They may not acknowledge it. In fact, they won't acknowledge it. They may not do anything with it. But it's your responsibility to report it, because when they do come and do like a check on your systems and that you've reported everything, then if you're found not to be compliant, you can actually have your license suspended or revoked. Also things like if you take on a carer and you promote them to a senior carer, you have to then report that to the UKBI. If your member of staff is off for more than 10 days without your permission or consent, you have to report that on the system. If they're under any sort of disciplinary process, you have to report that on the system. And again, please remember that they do have the option to downgrade you, suspend your license, or revoke your license if they feel that you haven't complied with those. Now, the worst case is if they were to revoke your license, that means that you no longer have the license to employ the people that you have sponsored, and they have 60 days to find another sponsor, and they have to leave your employment almost immediately. So very, very important that you understand what your responsibilities are, and that you actually are able to make sure that you monitor that and report those back. So, as I said, there's a number of things that you have to do. Record keeping, for instance, there is additional record keeping that you have to have for your migrant workers. You have to have their phone number, not just their current phone number, but you have to have a history of their phone number. You have to make sure that you've kept all their details. If they move address, you have to keep a record of all the addresses that they've been at since they've been in your employment. Disciplinaries, supervisions, all that sort of stuff has to be kept, which you probably do for everybody, but the UKBI, when they come and inspect, will want to see that that person is doing the job that you've employed them to do. So it's very important that you keep those records. They also monitor as well. So again, they'll have a benchmark of how many providers there are, what they're reporting, what they're not reporting. And if you fall sort of below that benchmark, you then sort of almost flagged up on their system for an inspection. And very much like CQC, they'll just come in, they won't tell you, they'll grab some of your migrant workers, they'll want to see them, talk to them, make sure they're doing the job that they're sponsored to do, and they will interview them. And unfortunately, you don't have a right to be there when they're interviewed. It's very much like CQC, and quite often they'll come in with the mindset that something is not right, and they just want to make sure that everything is. So it's important that you monitor everything, you report everything, and they want to see total cooperation. They don't want to see evasive answers or hear evasive answers or anything like that, because they come with suspicion in mind. And it is the law, so you have to comply with the law, because they also have the right to prosecute, and effectively, as I said, they're passing that responsibility of immigration onto the provider and onto the person who is effectively the license holder. So they're expecting you to know what the rules and regulations are with regards to managing their part of the sponsor management system, and you're expected to be compliant. Now, it sounds a bit harsh, but quite often it sort of changes with the wind as well. We've had inspections where an inspector's come along and said, you really need to do this, can you change that, can you add this to your policy? And they're quite cooperative. On other occasions, we've had an inspector that said absolutely nothing and then sent us a 30-page letter of breaches, and that could be that somebody was off for 10 days and you didn't report it, or it could be that they've taken more than 28 days holiday, or they've been out of the country for more than 28 days and you didn't report it, and that's a breach, and they'll hold those breaches against you. So best to keep on the safe side, keep it all up to date, keep your records going, and everything that goes with it. So so some of the other things that are important, record keeping, for instance, make sure you keep a copy of the migrant's passport. Now, we always used to keep the copy of the page that had their visa on it, and also had the main page with their passport page. And we had one inspector and said, I want to see every page. We said, but there's nothing on the pages, so why would we photocopy 30 pages of a passport that if they've got nothing on it? But again, don't argue with them. He even wanted to see the front and the back cover of the passport. So again, you just don't know how they're going to react. So if you've got a passport, copy the front and back cover and every single page in it. And then the other thing that you've got to do is just sign every copy that you make to say that you've checked it and it's a copy of the original and you've signed it and dated it. And what you're supposed to do as well is every year, and we set a date sort of 1st of January, literally check their passport. If there's no changes, just sign it again and date it again saying no change. If there is a change in their passport, for instance, they've gone on holiday, they've got a stamp or something, then just copy that page and say this is the only change. Up until I think the end of this month, you also need a copy of the migrant workers biometric card or residence permit, but that's changing now, because then from April, I think they're no longer going to issue the cards and it will be an online service. So effectively what you do is if you do a right to work check on the government website, it will automatically bring up their sort of biometric status, and it will give you the details of that, and it will either be a tick or a cross, a green tick or a red cross. So I guess as a matter of course, what we do is anybody that hasn't got a UK passport, even if they have the right to work here, so for instance you may have a European member of staff that has the right to reside and work in the United Kingdom because they were here before Brexit, just do a right to work check on their details. It doesn't cost you anything, and once you've got that certificate, put it in their file. It just shows, one, that you're compliant, two, that you have a process and a policy to do that, and three, that you're not discriminating against, I guess, overseas people and people of different colours and origins and whatever, because somebody looks white and English doesn't mean that they don't have a UK passport. So you have to sort of follow that process. So if they've got a United Kingdom passport, it's fine. But somebody that's got a French passport that may have lived there all their life still needs that right to work sort of check, and that shows that you're not discriminating in any way. When you've got a new migrant worker, you obviously have to have a copy of their national insurance number for payroll records, but keep a copy in your file just for the Home Office to see as well. As I said earlier, history of the migrant workers' address and contact details. With everybody else, you just keep their current address. You don't necessarily need their previous sort of address history other than for DBS purposes. But if a migrant worker changes address, you have to keep that history in a file somewhere, or particularly in their file, to show that you've actually monitored it, the date they moved, where they were before, where they are now, any changes in phone numbers as well. Again, copy of the DBS. You also have to keep a record of their holidays and absences. If they're absent for more than 10 days without your permission or knowledge, you have to report that on the SMS. If they're out of the country, keep a note of it, because obviously many migrant workers will want to return home, to visit family and friends. And what we find is, and what we allow for, is that if you've got somebody going to the Philippines, they're not going to take a week's holiday to go to the Philippines and then another week next, in a couple of months' time. They typically want to use 4 weeks holiday in one go because of flights and everything else, and they will go away for that period. But what you've got to remind them is that they can't be out of the country for more than 28 days, because that may affect their re-entry back into the United Kingdom when they arrive at Heathrow Airport, for instance. If they've been out of the country for more than 28 days, they may not let them back in. So make sure you let your migrant workers know that. And generally, I don't know whether anybody gives more than 28 days holiday, but that's about the limit. Oops, where are we? Okay, the other thing that you have to do is keep a copy of, oops, no, sorry, keep a copy of the migrant workers' payslips. The reason for that is that you have to demonstrate to the UKVI that you are paying them the minimum salary of £10.10p per hour or £20,480 a year. And the best way to do that is keep a copy of their pay records or pay slips, or something that shows that they are being paid that rate. You also have to remember that if they do overtime, which many migrant workers will want to do, and you will probably offer them, it has to be paid at that same rate or above. You can't say that, okay, your first 39 hours is £10.10p and your next overtime is at a lesser rate. And some people do that, and they shouldn't. And if they get caught doing that, again, it'll be reason for revocation of your sponsor license. Obviously, you keep a copy of the contract of employment. So again, what we do is, with your migrant workers, when you issue their contract of employment, you need to add a clause in there, because it needs to be for the period of their sponsorship or visa, whichever expires first. So just add that clause. You can add it to all your contracts, so it's generic, that if they're sponsored, their contract length is that period. But what you can't do is it's not continual employment, because if you give somebody continual employment and you've only sponsored them for 18 months, effectively they could, you've got a conflict in their sort of certificate of sponsorship and the contract of employment, and you don't want that. So make sure you make provision and add that in. Job description. Again, all your employees will have a job description, but particularly with migrant workers, if you're sponsoring a senior carer, then make sure they're doing the job of a senior carer. So you will have distinctions between what the carers do and what the seniors do. And that additional responsibility could be writing care plans, it could be medication, it could be supervising shifts, it could be dealing with doctors and nurses and paramedics because they're the senior on shift. You have to demonstrate, and they also have to demonstrate, that they are able and capable of doing those additional duties. It's not a question of pick one and they do that, because when they come and interview them, they will look at that job description of a senior carer and say, right, tell me the last time you had an emergency and had to deal with the paramedics and what happened. And they may go so far as cross-referencing that with your care notes as well, to make sure that they actually entered those notes in. If they suspect anything, they will dig deeper and deeper and deeper until they find what they're looking for. So don't give them a reason to look for anything in the first place. Please make sure that they understand their job description and they are following that to the letter. If you hire somebody as a senior carer, make sure they're doing that job. If they're not capable, if after a few months you think, actually, do you know what, they're not capable of doing that job, you may then have to drop them down to a carer. But unfortunately, you still have to pay them the same £10.10p an hour rate. But you also have to notify the UKVI on the sponsor management system, and they may or may not sort of revoke that certificate of sponsorship, but because carers are on the shortage occupation list, they shouldn't really have any issue with it at the moment. As I said earlier, anything that you pay that migrant worker has to be at that rate or above. So you like, as I said, if they do overtime, it has to be at that same rate or above. It can't be any less than what there is at the moment. Previously, you had to do what was called a labour market test. So you could only recruit people from overseas if you could demonstrate that you needed migrant workforce as opposed to employing domestic staff. Now, although there is no formal requirement or legal requirement now to carry out a labour market test, you have to, or may be asked to demonstrate why you employed a migrant worker over a domestic worker. So if you've got two applications, one from somebody down the road and one from somebody in Nigeria, for instance, you would have to prove or demonstrate that actually they were the better candidate because of whatever. Although, like I said, it's not a formal requirement, but it's good practice to make sure that you can demonstrate that. Also, keep copies of any job adverts that you place. They may come back to you and say, right, you employed this person 3 years ago. How did you get them? It can't be, you know, Uncle Joe's friend in you know, Germany that you're helping out to bring over to the United Kingdom or whatever. You have to show that, one, you have a need, and that you've advertised the job and it's open to all, and that there was no discrimination, and also to demonstrate that, you know, that job is open to all, local, foreign, or sort of, you know, UK-based staff. Keep all information regarding that job advert, so information about where the job was advertised, how long it was advertised for. It's good practice anyway, but you know, you may be required to produce that. You also need to keep some sort of spreadsheet, I guess, of all the people that applied, and how many people you shortlisted for that job and why you selected that particular individual. I'll give you another example. Years ago, we had a breach because one of our managers said, was asked a question under caution or interview or whatever, and said, so why did you employ this person as opposed to anybody else? And his answer was, I'd rather have foreigners because they work harder. And they took that as that it was discriminatory. Now, whatever your personal feelings are about where you employ and who you employ from, you've got to be careful not to sort of demonstrate that you're giving preference to overseas workers over the domestic workforce. So I guess it's just a question of making sure that you're careful and that your selection process is quite robust, and that you can prove going back 3 or 4 years and you've got those records, because you may not remember who applied for that job 3 years ago, but if you can demonstrate that you've got the records, and you know, Joe Bloggs from down the road failed because he didn't have the right qualification or didn't have the right attitude or didn't have the right experience, you can then prove that point. So at least one other item of evidence that you need to show is you, again, identifying that you've picked the right candidate for the job, and as much evidence as you can collect and file in that person's records is better for everybody. Okay, so monitoring and reporting. So as I said, you have to report things within 10 days, 10 working days of anything that the UKVI put on their website that they think or deem as as a reportable incident. So, as I said earlier, if a migrant worker doesn't turn up for work on their first day. So, again, when you issue the certificate of sponsorship, you have to put a date in. So if I was issuing a certificate now and I thought, okay, it's today's the 9th of March, it's going to take them 6 weeks to get here, and you put in a date, say the 1st of May, for instance. Now, the likelihood of that person arriving for work on that day is, well, you can work out that they've got to get all their paperwork together, they've got to book flights, they've got to do everything, and the flights may not always arrive. They can't come before that date, but they can arrive after that date. So if they don't arrive on their first day, put a note on the sponsor management system to say, haven't arrived on this date because their visa hasn't come through, extended by 2 weeks. If they still haven't arrived in 2 weeks, then put another note on the system, got their visa, flight arrangements being made, start date delayed by whatever time, 2 weeks, 1 week, or whatever. So make sure that, if they don't arrive on their first day, keep that up to date. If you take on a migrant worker and you find that actually they're not suitable, they're not who you thought they were, they don't have the skills that you thought that they might have, then, and you have to terminate their employment, you also have to notify the Home Office on the sponsor management system that you're cancelling their certificate of sponsorship, and they then have 60 days either to find another sponsor or to leave the country. Separate issue on that. When you're employing people from overseas, you do have to be extra careful. We've interviewed people on Zoom, Skype, whatever, and they've spoken eloquently and given you every answer in one sort of, you ask one question and they'll answer like 10 of your questions because they've been trained, they've been briefed, they've been told what to say, they've almost rehearsed a script. And then suddenly, when they arrive in the UK, their knowledge of English isn't that good, their confidence isn't that good, they haven't understood half of what you expect them to understand. So, there may be instances where you get people that do that and you have to let them go. So you're within your rights to do that and to cancel that sponsorship at any time you like. But again, report it on the system. It's imperative. As I said, if they're absent for more than 10 days without your permission, it's likely that they may have gone AWOL. Again, you do get candidates that they get their certificate of sponsorship, they get their visa, they come and work for you for 10 days, and then suddenly they find that Uncle Joe lives in Edinburgh, and they want to go and live with Uncle Joe because they get free accommodation, and they think now that they're in the country they can go and do whatever they want, work wherever they want, and actually that's not the case. So you have to make sure that they understand that when you sponsor them for a period, they are tied to you for that period unless they find another sponsor, and they must give you notice. And if they don't work with you on that, again, you have to report it to the on the sponsor management system. All absences need to be authorised, including leave, sickness, study leave, overseas travel, and again with absences that other than sickness, if they're off for more than out of the country for more than 28 days, you have to report that as well. And as I said, if there's any significant changes in their duties, as it were, for instance, if you employ them as a senior and then you may well promote them to something higher, so then again report that. On the other hand, you may demote them to a carer because you don't feel that they're capable of being a senior. Report that as well. So it works both ways. Years ago, we had an instance where we had an amazing senior carer, and in recognition for the work that she was doing, we promoted her to like an assistant manager because she virtually ran that place alongside the manager, and it allowed the manager the time off that they needed. She covered weekends, evenings, she lived on site, so she was effectively running the place. And we said, well, do you know what, she's like the assistant manager. So we advertised for that post, we promoted her, but didn't inform the Home Office. And again, what we thought was a good thing for that candidate actually turned out to be detrimental and was a breach with the UKVI. And they said, well, you didn't report it. So they're looking at things that you don't report. So make sure, good or bad, stick it on the system. As I said, you're also expected to monitor the immigration status of your employees. And as I said earlier, check their passports. We check them once a year. Sometimes we check them twice a year. Just depends on if you're auditing all your files, get them to bring it in. And that may well be that, you know, they may have done something that has revoked their visa, but they haven't told you. Again, that could be incidents that involve the police, where their visa's been affected that you don't know about, and you could carry on employing somebody without actually that knowledge. So make sure that you check their immigration status on a regular basis. So we do it once a year, set a date in your calendar, get everyone to bring their passports in and double check them. So organizational reporting, basic things like if your registered office changes. Now, I don't know, if your managers, your provider may have a registered office which is different to your home. They may change accountants, which may change the registered office. So make sure that you know, you're aware of those things, or whoever the license holder is must make sure that they inform the UKVI of any company change of address. If there's a change in authorising officer, so for instance, I am the principal sort of license holder for the UKVI for our company, but I also have two authorising officers that work for us. So they basically can log on to the system in their own right, and they make those changes or notifications on the system, you know, rather than me having to do it, because I don't always get that information. And if you change those authorising officers or you add somebody, please make sure that you notify the Home Office through the sponsor management system. If your group is adding a home, or it closes a home or adds a branch, then again you need to notify the Home Office through the sponsor management system. And any other changes like takeovers, mergers, you know, to transfers. So if you're adding another home to your providership, for instance, again you have to notify them. So applications and renewals of certificates. So when a certificate of sponsorship has been allocated, you've got to assign it to a worker within 3 months. And that's basically, they give you almost like an expiry date on those certificates. Sometimes there's a rush to do that. And on occasions, what they're doing now actually is they're extending those dates as well. Some people are getting dates for certificates that they have to issue within 12 months as well. So a lot of that depends on your, if you say you need to employ 6 people, they will give you 6 certificates of sponsorship or an allocation for 6. If you haven't used those 6, they may expire. So keep a note of those. And if you issue a certificate of sponsorship, that applicant must start with you within that 3-month period. And they must apply for their visa in that time, because once that document expires, it's gone. That certificate of sponsorship is wasted. That £199 that you've paid is wasted, it's gone. So you need to issue that in a timely way, that the applicant is then going to apply for their visa within that time scale. The allocation of certificates expire at the end of each financial year. So 5th of April they expire. And what you have to do from January, for the beginning of January, you have the opportunity to renew your application for certificates. So what we do is, if we've got 3 left over and we think we need another 6 for next year, we then put in a request for an allocation to be extended at that time. You can apply for more throughout the year, but the earlier you do it, the more. So from April, they'll then give you another 6 if you justify it. So you must only issue certificates, as I said, that are suitable for sponsorship, and you've got to make sure that the candidates that you issue that certificate for, they're given a job code basically, which I can sort of run through separately. And that job code relates to, I think it's 6146 or something for carers, but they've got a whole list of codes that they use for different jobs, and you must make sure you use the right code, because the codes determine the skill qualification, the level of pay, and everything else that goes on that certificate. So if you put the wrong code down and you issue that certificate and it doesn't match what the employee is doing or the job description, again, you'll lose that, and you'll lose that £199 as well. Unfortunately, the Home Office are very unforgiving. There's no emailing them or saying, I made a mistake on that, can I change it? You do have the option to add sponsor notes onto a certificate, but effectively, if you put the wrong information down in some of the areas, it's at their discretion whether they allow you to change it. But experience teaches me that they're very unforgiving. So when you issue a certificate, make sure it's right, double check it, get someone else to check it as well. Very important. I mean, we're working with a provider at the moment that basically issued 3 certificates of sponsorship, and all 3 of them had the wrong code, and they £600 just went down the drain, and they were absolutely gutted about that. So now what they do is they do a draft certificate, they'll print it out, scan us a copy, we'll just double check it with them, and then then they've hit the go button, and they've got it right. So the visa holder, again, like I said, it's a fixed term contract. So please make sure that when you issue your letter, your job offer letter, it specifies that it is a fixed term contract of employment, and it's in line with their the certificate of sponsorship that you've issued and their visa that has been granted by the Home Office. And it's fixed for that duration, as I said. The other thing, fixed term contracts, you can pay your staff, those staff, more. And again, it's hard to justify to your existing staff why you may be paying a migrant worker slightly more than your domestic staff, but it's the nature. The Home Office have argued that because it's fixed term, you can pay them more. Whether that causes any conflict in your organisation or not is a different thing. We had a migrant worker that said, "Oh, I get paid £10, 10p an hour," and our other seniors at that time were getting sort of £9.90 an hour or something. And they said, "Well, they're doing the same job. Why aren't I getting paid?" Right, we're leaving. So we then matched that rate last year with all our seniors. So again, it's something that you have to determine. Hello.
Oh, Raj, we can hear you.
You can hear me? I don't know, I've lost you. Right, let's see if I can get you back. No. Gosh, where have you gone? Do you know what? I can't seem to.
We should be, I think, because you joined via the internet, don't you?
That's
Got
it.
us?
Yeah, got you back.
Brilliant.
Sorry.
That's all right.
I thought I put it on Do Not Disturb, but it seems to have bypassed that on my other device. Okay, where were we? Yeah. So yes, you can pay more, but you have to justify that to your existing staff. So again, as I said, make a clear distinction in your job description as well, that why you're paying that additional amount, the additional skills, in order to avoid any sort of discrimination claims. Because at the end of the day, if you've got a carer that's on £10, 10p an hour, and you've got a migrant carer that's on £10, 10p an hour, and you've got a domestic member of staff that's on less than that, and there's nothing in their terms of employment or job description, then you could be facing discrimination claims. So please make sure that you've got that to hand. Okay, so what I'm going to do is leave it sort of open for questions, really, because there's probably a lot of information there for those of you that haven't actually embarked upon the process, and those that you that have embarked or just starting the journey. Again, it's only the beginning of the journey, and it's quite complex, and there's a lot of pitfalls. So, has anybody got any questions that they'd like to ask, or things that they might want to
Just a reminder, you're on mute, so if anyone wants to ask anything, you can pop yourself off mute just to ask any questions, or pop them in the chat.
Yeah, Raj, I've got a question. With current employees that have been working for us for a number of years, but they don't have a UK passport, but obviously are allowed to work in the UK, do we still have to get a right to work check on them?
If they haven't got a UK passport, then I would just get a right to work check. You know what? You just got to cover all the bases. At the end of the day, what you don't want is somebody coming in and saying, well, why did you do my right to work check? Because I've got an Indian passport, and you didn't do theirs because they've got a French passport.
Right, okay.
And also, you need to ensure that actually that French passport holder may not have had a right to work. You don't know now, unless they've got residency here in the United Kingdom, or they were part of the European sort of scheme where they could register prior to Brexit, allowing them to work. Unless you've got some evidence of that, basically anybody with a foreign passport has to be treated the same. So get a right to work check.
So would they have all been sent the share code?
They have to make that up. What you do is, I think you go onto the system, you give them a reference number, they then get the sort of login code allowing you to share information, and then you just follow the system. They wouldn't necessarily get that until you make that application.
Right, okay.
So Raj, on that question, can I ask the people who've been our employees, say till April this year, do we have to check their right of work again?
Sorry.
And they may not be holding the British passport.
Sorry, could you repeat that?
I said if they don't have the British passport and people are working, say they may be from Philippines, we've seen all their evidence.
Yeah.
You've got the right to work, but we don't need to check their work again.
They have a right to work. It will say I have conditions.
They have a
right to work.
Right to work.
No need to do it.
No, I haven't got them.
So again, what I would do, matter of course, if they haven't got a British passport, just do the right to work check, see what information comes up on there. There may be limitations on their right to work. For instance, they could be a student for instance, that's here, and they can only do 20 hours a week. So you need to be aware what their immigration status is and whether there's any restrictions on their working. And that's, again, very important. Students can work 20 hours a week, and in the holidays they can do pretty much anything that they like. So just be aware of what their limitations are, and the easiest way to do that is get a copy of their passport, do the right to work check, because from April it will also have the biometric details, which will tell you what they can and can't do. Yeah. Any other questions?
Oh, I can't see any more at the moment, Raj. Nothing in the chat either.
Okay. But if you do have questions, I'm sure Megan can share my email address. I'm quite happy to, if you drop me an email, I'm quite happy to sort of answer it. Yeah, I always say to people, it's a long and complex process. If you haven't embarked upon the scheme, you know, and you need to get a license, that process itself of getting a license can take you 2 to 3 months. And once you've got your license, like I said, it's understanding the difference between defined and undefined causes, what you can and can't do. You won't get an allocation of causes, so you need to apply for those separately. All those sort of processes can be quite daunting if
we haven't stated if we want defined or undefined.
Sorry, Michelle, you're not muted.
Yeah, sorry, I just had a couple of questions. Firstly, just quickly going back to when we asked about current staff and checking their right to work, does that still apply if, for example, someone doesn't have a UK passport, but they're married to somebody that does have a UK passport, so they have leave to remain? Do we still need to do a right to work check on them?
Right, so if they've got leave to remain, then in theory that is your proof. If in doubt, do the right to work check. It doesn't cost you anything. It literally is a 2-minute process to fill out a form. What you got to remember is that if you employ somebody that doesn't have the right to work, you could be fined up to £10,000 per person. So for the sake of 2 minutes work, I would do it anyway.
So if somebody's got divorced from somebody that had a UK passport and they didn't, something like that, we would need to check if in case the regulations have changed, or?
Yeah, if they've got divorced and they've got their residency by virtue of marriage, then nothing has changed. You can't expel somebody from the country just because they've got divorced. I don't think that sort of comes into it. But again, as I say to everyone, it's a 2-minute process. You know, get the check done. It saves the any sort of ambiguity and any sort of risk of. I mean, a £10,000 fine is a lot, and I think it's going up later in the year to £20,000.
Wow.
So they're
worth doing.
Oh, yeah, absolutely. I mean, why risk it? Just do the check. I mean, our managers basically say anybody that hasn't got a UK passport, there's no discrimination. Do the check.
Yeah. Okay. Sorry, the only other question we had on it, we've just been issued the sponsorship license, and we were given a maximum of 2 sponsorship certificates for each year. Is it just as simple as going on the sponsorship management site and just sort of applying for additional ones as and when we find people, or what's the best sort of way to increase the numbers?
Right. So what you've probably got, if you've got a new license and it's on your license summary and you've got 2, that will be for people that are already in the UK. Hidden in the system is your defined cost allocation, and they don't give you any.
Right.
So, I'm working with a few providers that wanted to employ people. They wanted 3 or 4 people from the Philippines, and they tried to issue the undefined causes for those people and wasted the allocation that they had because it didn't get approved, and ended up with nothing at all. So again, it's a question of sitting down and making the right application. So have you got 2 people that you want to employ that are migrant workers that are already in the United Kingdom?
Well, it doesn't actually say on the sponsor license that we received. It just says the maximum number of skilled worker certificates of sponsorship you can issue is 2.
Yeah.
It says you have not stated whether the COS required would be either defined or undefined. So how do we find out if those 2 allocations are defined or undefined?
Right. So what I can do is, if you want to email me separately, I can get someone to literally sit on our system and you sit on yours, and they will guide you through that process, because it's hidden under layers of menus, unfortunately. One of the things that I've been, I'm on the board of like the National Care Association, and I've been using the sponsor management system our company has for almost a decade. I've always maintained that it is unfit for purpose, because now, particularly after Brexit, so many more people are using the system, and it is almost impossible to navigate if you don't know what you're doing.
Yeah,
it's very, very difficult. So again, if you want to email me or send me your contact details, like I said, I've got we sort of know what we're doing with it, because we've been doing it for long enough now, and I can send you a separate sort of little presentation thing which sort of takes you through it in a little bit more detail than what we've done today, because like I said, the SMS is actually quite complicated. But if you want to have a chat with somebody, I can put you in touch, and they'll sort of run you through it. And like I said, what we do with other providers is I've got a lady, Jasmine, and she'll sit on our system and say, right, now click this, now click that, go into that, this is where it says this. And you can either take notes or run through it with her, and then it will show you the different parts of the system. And unfortunately, that's not something that the UKBI offer, and the system is very difficult to navigate, because the language that they use is so difficult as well.
Yeah, different jargon.
I mean, like the difference in defined and undefined, I even have to sort of think about that myself. Well, which is which? I can't remember.
That's a question we have. So defined is obviously somebody that's coming from abroad. So if we've been allocated undefined, how does that work if somebody is classed as defined working elsewhere on their sponsorship and they want to move and come to us? Are they then classed as undefined because they're in the UK?
Yes.
Yeah. Okay.
Effectively, they're classed as undefined, so it's basically transferring. They're already here. So the rule of thumb is if they're
defined becomes an undefined.
Yeah. If they're in the UK, it's undefined. If they're outside the UK, it's defined. Why that definition of defined and undefined doesn't actually tell you anything at all. No. And that's what I'm saying. The whole language of the sponsor management system, it was created over a decade ago, and it is not fit for purpose. I'm working with the group, the ECHO group, to look at the whole system and try and make it easier, and to use language that is understandable by most people. I still, for the life of me, can't figure out why we have to have defined and undefined, because you're sponsoring somebody. So what is the difference? What difference does it make to anybody? Why not just have a number of certificates that you can apply for? There's so many things that need improving, and it will happen in time, because it's not just the care sector that's using this. It's transport, it's retail, it's hospitality, all the jobs that are on the shortage occupation list, and there's hundreds of them. All those people that could previously employ people from around are now having to use this system, and they're all falling foul of the same issues that everybody's having. And it's causing a lot of complexities. So, like I said, if you want to drop me an email afterwards, I could put you in touch with Jasmine, and she will run through it with you. And go through it, and you can do it on you can sit in front of your computer, and she'll sit in front of hers, and you just have the phone on and say, right, this is what you do, and she'll sort of give you a little bit more information than I've done today.
How does it work? Sorry, just one final question. If somebody's already here on a sponsorship at another organisation, so they're in the UK and they want to come and work with us, how straightforward or what's the process for transferring them, for arranging that?
Right. So effectively, what you have to do is issue the certificate of sponsorship. They will already have a visa to work in the United Kingdom. Now, it's the certificate of sponsorship that has to be transferred from one employer to another. So you have to work with this other employer. It's not an easy process, but once you've issued the certificate and you've given them a start date, their visa will, and it has to be to the end of their visa date that you have to sponsor them till. And then the other employer has to notify the Home Office that they are letting them go and to take them off their system and to put them on yours.
Right. Okay. So is that slightly quicker than doing a transfer of employer as such, than sort of going down a separate route?
There's not really much different. If they're already in the United Kingdom, it doesn't really matter. What they may have to do is get that checked with a solicitor to make sure that their visa is still valid. A lot depends on what that other employer has put on their sponsor management system, and obviously you're not privy to that. The Home Office is. So once you've issued that certificate, the Home Office will marry up the two and say, right, they've left this employer and they've joined this employer.
Okay.
But you still have to go through the usual processes of taking up references, taking up doing the DBS and all the usual things that you do, and do the right to work check. Make sure their biometric card is. Well, you won't need a card anymore, but it will be done online. Their biometric certificate, their virtual certificate is valid. Their passport details are valid, and that other employer releases them from their sponsor management system. That's also key.
Can they refuse to release them?
No, not technically. It's like not giving somebody a reference.
Right. Okay.
However, we all know that if we've got somebody good and they suddenly say, well, I'm leaving to go to so and so, you sit there and try and talk them out of it, don't you?
Yeah.
And you say, look, we've sponsored you, we've paid for this, we've paid for that, and depending on their contract, for instance, they may say, right, well, we've spent all this money on your training, and in your contract it says that you've got to repay that money, and suddenly if they find that they've got to pay £1,000 back, they may be less inclined to move.
Yeah.
So you really need to understand what their contractual terms are with their current employer, as opposed to you moving them.
So would it be the employee that would broach their current employer to say that they want to move? Would they be the ones that sort of start the process?
Yeah, I guess it's like everything else. If anybody wants to move jobs, you at some point have to hand in your notice. But at some point, you also have to take up references. So generally, you give them a job offer letter and a certificate of sponsorship. But what you don't want to do is issue that certificate of sponsorship, pay £200, and then they say, well, actually, I've decided to stay. Because you've wasted that money. And not only the money, but if you've only got two certificates and you've wasted one of them on someone that isn't going to move, you're going to be gutted. So it's a risk that you take. In addition to, if you're employing anybody else, really.
Yeah, of course.
I mean, if we get people that want to leave, if we're not entirely happy with them, we don't say anything. We let them go. On the other hand, if you spent a lot of time, effort, and money training somebody, and they've come in from overseas, and suddenly they say, well, my uncle lives in Birmingham. And I want to go and stay with him, and I've got a job over there. And we've had one. So we had a lady that came from Newcastle, or somewhere in Tyneside, her visa was running out. We gave her an induction, we sponsored her, and literally within a month of that, because she got her visa extended, she wanted to move back to Tyneside where her family was. And we said, well, you have to find another sponsor. You can't, there's a myth with them that they've got their visa, now they can go.
So they can just go, yeah.
And then when she realised that actually she couldn't go to anybody because her visa's been stamped, you know, then she suddenly realised that actually you know, this is going to be a bit more difficult. So 3 months later, she found a sponsor that was up in Tyneside somewhere, that was willing to do that. As it happened, she wasn't particularly great, and we said, okay, we'll let you go now that you've got a sponsor, and let them carry on with that. So again, it depends on the employee, how good they are, if they're willing to let them go, or if they're willing to, you know, convince them to stay.
Okay. So if on the other foot, say we had somebody that was one of our 2 allocations and they transferred elsewhere, do we get that allocation back, or is that it's still gone for those 12 months?
That's gone.
Right.
So if you've got 2, even if you issue it and that person doesn't join you, that's gone. If you put the wrong code in and you've paid for it, it's gone. Like I said, the Home Office are very there's no refunds, no exchanges. They operate the worst possible terms for employers. You know, you use it, you lose it. That's it, as simple as that.
I like the word, use
So
it, lose it.
a bit of a gamble, isn't it, some of it?
It is. There are better ways, and again, you know, if you want to have a chat offline, you know, I can tell you what we do. Give you an example. We've got 28 migrant workers at the moment, all of which are happy. Some of which have come from within the United Kingdom, and 20 of them have come from outside the United Kingdom. So again, it's like all your staff. You've got to keep them happy. You've got to understand what their needs are. You've got to make sure that, you know, their sort of pastoral needs are met as well. Because if they've literally flown in from you know, Ghana or somewhere, when it's the first flight they've taken, they've just landed here, they know nothing about culture, the food, the accommodation, the travel, the transport, the work. You know, there is a little bit more work, but I can also tell you that it's very, very rewarding, because, you know, those people will be with you for 3 to 5 years if you look after them.
Is it quite straightforward to, if their 3 to 5 years is up, to reapply for them to stay?
Okay, so government rules and regulations change by the day. Today, carers, or last year they put senior carers on the shortage occupation list. And Christmas Eve they announced carers to go on the shortage occupation list. You can employ these people for 3 to 5 years. Incidentally, if you employ somebody from outside the UK, you only get 3 years, and inside the UK it's up to 5 years. So you can employ them for issue the certificate for 5 years, but in 5 years' time they may be off the shortage occupation list.
Right.
So it's unlikely, because following Brexit there is always going to be a shortage of staff. I mean, the care sector has probably in excess of 140, 150,000 vacancies. That's growing in terms of needs, because the need for carers is increasing while the workforce is actually probably diminishing. So, but you know, we can't predict what's going to happen in 3 years or 5 years. If the government decides to take those jobs off the shortage occupation list, then they don't get the points, they don't meet the criteria, then obviously it's a whole different ball game, really.
Okay, thank you.
But at least you've got 3 to 5 year commitment. I mean, with a domestic workforce, you can employ somebody. They may say, do you know what, I really don't like this job. I'm sorry, it's not for me. I've got a better job working in a supermarket that pays more.
Absolutely, yeah.
So whereas the people that you employ, that you sponsor, they're committed to you, and you've got to be committed to them. So like I said, it's like everyone else, you look after them. I mean, I would say to our staff, look, you scratch my back, I'll scratch your back, I'll make sure you look after you. We help them with accommodation, we literally pick them up from Heathrow Airport. When it's time to quarantine, put them in hotels for a couple of days or whatever. We'd pick them up, take them shopping, we'd show them their local supermarket, whether if they came from Asia, show them Asian supermarkets.
Arlene or Michelle, one of Arlene definitely.
So it depends how much.
Brilliant. I think that's it for questions, and I think we're at the point of time coming up.
I've got
Was
a
there
last
any last?
question.
Yes,
Won't
yeah.
be long. How does DBS check fit in?
Right. So you effectively used to, when they arrive from, if they arrive from outside the country, they have to, part of their visa application, they have to have a police check from every country that they've resided in for the past decade.
Okay.
So you've got, for instance, some of our migrant workers, they're based in Dubai or they're based in the Middle East, but prior to that they were in India. Prior to that they may have been in so they will have to have a police check from every country. Now that itself can take time. You can imagine the complexities that if you're living in Dubai at the moment and you have to have a police check from the Philippines, hopefully they would have got that when they left, but if they haven't, then you have to get that documentation. We actually use an agent that does all that for us. They will get the documentation. They work with the candidate to get that documentation because they need that for their visa. So when they arrive here, and if they've never been to the United Kingdom, which will obviously it will show on their passport, then you effectively have, I think it's up to 3 to 6 months to get a DBS for them.
Okay.
Again, good practice. You don't have to because they've had police checks outside, but you know what? For CQC, their rules are different to the Home Office. So you can't get a DBS for somebody that hasn't got the ID for the UK. So when they arrive here, they first have to get a national insurance number, register with the doctor, get a bank account, get all the, because you need to produce the identification for them in the United Kingdom to get the DBS, and that doesn't happen on day one. So give yourself a period of time to get their accommodation agreement, their bank accounts, their national insurance number, all these things, copy of their statement, phone bill, that sort of stuff, and then you can do their DBS as soon as you can. It won't show anything because they've never not been in the country for long enough, but again, it's good practice.
So will that apply for those who are already here?
No, for those that are in the United Kingdom, you have to do a DBS as per usual.
Okay. All right. Thank you. Very useful.